Do you ever see those news headlines about a massive strike or a factory lockout and wonder what is really going on there? Behind the picket lines and the dramatic statements. Well, it's way more than just a big argument. There's actually an official playbook for these kinds of workplace showdowns. So, let's dive in and really unpack the official rules for industrial conflict.
I mean, it's a pretty intense question, right? When an entire workforce just walks out, or when a company literally locks its own gates, it can bring everything to a grinding halt. Not just for that one business, but sometimes for a whole industry. It's a crisis for sure, but it's also a massive signal that something fundamental has broken down in that relationship between a boss and their team.
So, what are we even talking about here? The official term is an industrial dispute. And yeah, I know that legal definition sounds super dry. But what it's really getting at is a disagreement so deep, so fundamental, that it can literally paralyze a business. This isn't just a squabble over who left their lunch in the fridge. It's a conflict about the core terms and conditions of the job itself.
Okay, to really get why these disputes even happen, we've got to look at the environment where they're born. The best way to think about any workplace is kind of like a pressure cooker. There's almost always this low-level tension just simmering right below the surface. And really, at its core, this isn't about good guys versus bad guys. It's all about this natural friction that just exists. I mean, think about it. Employers are focused on things like productivity and profit. Employees, they're focused on fair pay, safe working conditions, and having some job security. A lot of the time, those goals pull in opposite directions, and that creates tension. The whole system we're talking about is designed to manage that tension. So what happens when that constant simmering pressure just boils over? Well, that's the moment we go from simple tension to full-blown open conflict. And it's usually very specific issues that act as the spark that just ignites the whole thing. And here they are, the usual suspects. Look, these big disputes rarely, if ever, come out of thin air. They're almost always kicked off by really concrete stuff. Disagreements over wages are a huge one. Arguments about working hours or safety on the job. The threat of layoffs, or maybe a disciplinary action against one person that the whole group sees as unfair. Any one of these can be that final straw.
Now, when a dispute finally does erupt, it usually shows up in one of two major ways. And even though they look different, it is so important to see them as two sides of the exact same coin. They're just different tactics in the same fight, started by different people.
So, on one side, you've got the strike. This is the tool the employees use. They all agree to stop working together to put pressure on the employer to meet their demands. And on the other side, the lockout. That's the employer's tool. They literally prevent employees from coming to work to pressure them into accepting management's terms. See the difference? One is a work stoppage led by employees, the other is a work stoppage led by the employer. Same conflict, different initiator. Now, obviously, with stakes this high, you can't just let these conflicts play out like some kind of chaotic street fight. It would be a disaster, and that's exactly why this formal system exists. We're calling it the official rule book, a legal framework built specifically to manage these fights and push them towards a resolution.
And this rulebook is basically built on two really old, really important pillars. Both have been on the books for over 75 years. First up is the Standing Orders Act of 1946, and right after that, the Industrial Disputes Act of 1947. Together, they're like a 1-2 punch for trying to prevent and then settle workplace conflicts. Let's break down how each of them works.
The 1946 Act is all about getting ahead of the problem. It's about prevention. Its main job is to make companies clearly write down and publish all the conditions of employment. Stuff like work hours, vacation policy, what happens if you break a rule. The whole goal is to get rid of any gray areas. You could seriously think of it as the prenup of the workplace. You agree on all the rules up front so you don't have to fight about them later.
But what if you have that prenup and a dispute happens anyway? Well, that's where the 1947 Act comes charging in. This law is the reactive part of the system. It lays out the official, step-by-step procedure for what you do once a fight has already broken out. It's the instruction manual for investigating what went wrong and finding a fair way to fix it.
Okay, so we've got the rules of the game, but who's the referee? In any big conflict, you absolutely need a neutral third party to make sure everybody is playing fair. And in the world of industrial disputes, that job, it falls to the state.
The government's labor department, both at the state and national level, steps in to be that impartial umpire. And their job is not to pick a winner and a loser. Nope, it's just to make sure that the process, the one laid out in that 1947 rulebook, is followed correctly by both the company and the workers.
And here's the path that they oversee. It starts with prevention, right? Having those clear rules and trying to negotiate in good faith.
If that breaks down, you move to step 2, conciliation. This is where a government officer comes in as a mediator to try and help the two sides find some middle ground. But if they still can't agree, it gets escalated to the final step, adjudication. The whole case goes in front of a labor court or tribunal, which hears both sides and then issues a decision that is legally binding. Game over.
So why does any of this matter? Why go through all this trouble, this whole elaborate system, for what might just look like a private fight between one company and its employees? Well, it's because the fallout from these disputes goes way, way beyond the factory gates. At the end of the day, this system is trying to achieve 3 huge goals. First, and most importantly, it's about protecting workers, making sure people aren't taken advantage of. Second, it creates industrial stability, preventing constant conflict from messing up the whole economy. And finally, by doing those first 2 things, it supports the overall economic health of the entire country. Because a stable, fair workplace is a productive workplace. Simple as that.
And this quote right here, it just nails the whole philosophy. The goal isn't some fantasy world where nobody ever disagrees. Conflict is a natural part of life. The whole point of this rulebook is to make sure that when conflict does happen, there's a clear, predictable, and fair path to get everyone through it without burning the whole house down.
But all of this leaves us with one final and I think pretty crucial question. This entire framework was designed for a world of factories of traditional 9-to-5 jobs. So, in our modern world of remote work, freelancers, and the gig economy, is this 75-year-old rulebook still the right one for the job? Now that is something we're thinking about.